Hi aspirants, hello everyone. So welcome to MVC Academy. This is Santosh Koka, Faculty of Polity and Governance. So previously we have already discussed two polity mock tests. Today we will discuss the Indian polity mock test 3. So you have already answered these 25 questions. One by one we will check the answer keys and explanation. So first question, that is concept of procedure established by the law in Article 21 of the Indian Constitution was primarily borrowed from the Constitution of which country, right? So these type of questions are completely relevant in the UPSC trend. So whether it is single option question, it is very important related to the examination pattern. So this is the concept of procedure established by law. So we have two concepts, especially we have already discussed the due process of law in the previous class or previous session. So this procedure established by law completely inspired or completely taken from the Japan Constitution, right? What is it means? So procedure established by law completely, that means a person's or an individual's life or liberty could be taken by the law or procedure established. Means here existed is very important. Existed procedure in the law, right? So that was taken completely previously, right? So after, if you observe the after 1978 Maneka Gandhi case, right? Maneka Gandhi case, right? So in this case Supreme Court interpreted this established or procedure established by law with the due process of law, right? So due process of law, that was completely included in the Article 21, right? We have already discussed this particular question. Due process of law was taken from the USA, right? So previously we have asked one question regarding this. So this is procedure established by law. What is the difference between them? Procedure established by law completely related to existed in the law, but later on Supreme Court interpreted this definition including the due process of law. Means here, so it must not be, it must also existed, and also it must be fair, right? Fair and just and also reasonable, right? So based on the situations, it can be changed according to the situations or circumstances, right? So this is the interpretation by the Supreme Court exclusively. So the answer is Japan. So next, consider the following statements regarding the National Commission for Scheduled Tribes. So we have already dealt with these constitutional bodies, especially in the previous classes and also in the YouTube classes. It is a constitutional body established under Article 330A of the Constitution. It is empowered to investigate all matters relating to the safeguard provided the Anglo-Indian community under the Constitution. So two statements were given. If you observe this, National Commission for Scheduled Tribes. So previously we have asked that National Commission for Scheduled Areas, right? So that is Article 338, right? So Article 338 and Article 338A and also Article 338B. These three are very important, right? So Article 338 is related to the protection of safeguards of the National Commission, means here scheduled areas, and 338A is related to the scheduled tribes, and 338B is backward classes. These questions were already discussed in the previous two mock tests, right? So here first option is correct. 330A is related to the scheduled tribes, and second option, if you observe, investigate all matters related to the scheduled tribes, protecting the safeguards or rights of the scheduled tribes only, not related to Anglo-Indian community, right? So if you observe this 338A provision, that was completely included by the 89th Constitutional Amendment Act, right? So 2003. These information are also very important here. So if you observe, this Anglo-Indian community related provisions were not related to the 338A, right? So those are very separate. So if you see the 331 and also 333, these articles are completely related to the provisions related to the safeguards of Anglo-Indians community previously, are not included, are not there as of now, So these were removed from the constitution, right? So by the 104th Constitutional Amendment Act, that was included in the 2019, right? So that is very important here. So if you observe Anglo-Indian community, this is not related to Anglo-Indian community, completely related to all matters related to the protection or safeguards related to the scheduled tribes only. Only one statement A is the correct. So which one of the following statements about the writ prohibition is not correct? So there are 4 statements which is the not correct, right? It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction. For example, we have certain court, right? Whether it is High Court, Supreme Court or High Court, right? So for example, they have given some judgment, right? So for example, High Court has given certain judgments, right? So if it is exceeding their jurisdiction, then automatically the higher court issue this prohibition, writ of prohibition, means just prevention. So to control them, this is not your area. Your area is, that is scope only, right? Jurisdiction of that particular area only. You should not enact related to or give judgments related to other areas, right? So it just prevent, that is prohibit, means writ of prohibition is issued by a high court to a lower court, whether it is Supreme Court to higher court, High Court, or High Court to lower courts, right? So otherwise tribunals also. Sometimes tribunals act as quasi-judicial bodies. They are also dealt with some cases whenever the cases are very important, or sometimes the tribunals enacted or established by some constitutional bodies, right? So why it is tribunals is necessary? To deal with some cases, to decrease the burden of the cases, etc., right? Important cases. So it is preventive writ, not a curative, right? So if you see the writ of certiorari, that is completely different, that is curative, but here prohibition is just preventive, to control, right? So this is not a curative one. So this is also correct. It can be issued against administrative authorities performing judicial or quasi-judicial functions. So sometimes administrative authorities who are performing these quasi-judicial, right, not only these courts, right, completely judicial, but also sometimes tribunals act as a quasi-judicial, means if you see the information commissions, right? So central administrative tribunals, they are acting as a tribunals here, right? So some senior most IAS officers also under this particular commissions, right? Information commissions, right? So Central Information Commission, State Information Commission, all these are related to the tribunals only, right? So they are completely quasi-judicial, not complete judicial, right? So here this is also very much important. That is correct. It can be issued against legislative body. Not correct, right? Completely this writ of prohibition is completely issued against these lower courts or tribunals or administrative authorities who are performing quasi-judicial functionaries, but not against legislative body or private individual or private body, right? So D is the correct option, not correct, right? So next, with reference to the doctrine of colorable legislation, consider the following statements. This is also very important. So these doctrines, every time we are discussing 1 or 2 doctrines in each and every mock test. These are very, very important related to the UPSC examination. So it is a judicial principle used to determine the legislative competence of the parliament and state legislatures. So it is completely doctrine of colorable legislature. For example, we have central government, right? Central government we have and state government we have, right? So whenever central government by using their legislation, parliament, right? So they are creating certain laws, right, according to their scope or jurisdiction. So apart from that, state legislatures also enacting some laws according to the legislation, means their jurisdiction. So sometimes if these laws are central laws or state laws are encroaching upon other area of the particular subject related to central or state, vice versa, then it will be invalid, right? Completely invalid. So this invalidation was done by the, will be done by the courts only, judiciary, right? So that's why it is a judicial principle used to determine the legislative competence of the parliament and state legislatures, right? So this is correct. It is applied when a legislature attempts to do it indirectly what it cannot directly. So what is doctrine of colorable legislation here? It means, completely meant that, so sometimes it cannot be, right? Sometimes cannot be done directly means, what is this? Cannot be done directly means, directly means we are following certain procedures given by the law or something, right? So that is directly. It must not be or should not be done indirectly also, right? That is, meaning is, it cannot be done directly means should not be done indirectly also, right? So that is very important, right? So if any government, whether it is center or state government, enacting a law in written format, so in reality, if it encroaches upon the other jurisdiction or subject matter, it is completely invalidated. That is the meaning of doctrine of colorable legislation. We can call it as fraud of constitution also, right? Other thing, that is fraud of constitution, right? So very much important. So this particular doctrine of colorable legislation was taken or given by the British administration only into the Indian Constitution. We have continued in the Indian Constitution 1950. Then later on we are completely continuing this procedure, right? So here both 1 and 2 is correct. Consider the following statements regarding the censure motion in the parliament. So it can be moved against an individual minister or a group of ministers or the entire council of ministers. It needs to state the reasons for its adoption. If passed in the Lok Sabha, the council of ministers must resign. These 3 statements, if you observe, this is completely wrong. What is censure motion? It is like a particularly criticism, right? So it's a motion that is related to criticizing or just disapproval of government actions or policies only, right? So not complete dissolution related things or resignation, right? So if it passed in the Lok Sabha, the council of ministers need not be resigned, right? So that is completely different. That is no confidence motion, right? No confidence motion is, then if it is passed in the Lok Sabha, the council of ministers must be resigned, right? That is no confidence motion. But here censure motion means, so it has to be proved their confidence later on, right? So it is just a step towards the no confidence motion, right? So here it needs the state reasons for itself. What are the reasons for its criticism or its disapproval? Their members are censure motions disapproval thing or against thing or criticism, they have to submit these reasons. That is also very important. This is correct. So it moved against an individual minister or a group of minister or council of minister. But council of minister need not be resigned, but individual minister may be resigned here, right? That is the meaning, right? So 1 and 2, only 2 statements are correct. Which one of the following statements regarding the National Human Rights Commission is not correct? We have already discussed these statutory bodies in the previous YouTube classes. If you have not seen it, please look into it, right? It is a statutory body established under the Protection of Human Rights Act 1993. So wherever we have some conventions or treaties or agreements mentioned in the United Nations, India already ratified so many, right? According to that, we just created this National Human Rights Commission, right? So this is correct. Chairman of the NHRC must be a retired Chief Justice of India or a judge, right? Judge of Supreme Court. This is also correct, right? So the recommendations of the NHRC are binding on the central or state government. Is this binding? So we have already discussed so many bodies or so many constitutional bodies or statutory bodies in the previous classes. No body or no constitutional commission recommendations will be binding, right? So just they completely create a inquire so many incidents or related issues, human rights issues, and they will recommend something to the central government, first, right? So based on that they can follow, or they have to inform these bodies, especially first of all within 1 month time, right? So 1 month time they have to reply them. So we have already started the procedure to enact these particular human rights related issues or something. So we are following up something. Central government or state government have to inform these bodies. That is the main information, that not binding, just recommendations are just suggesting, right? So commission can inquire into any violation of the human rights within 1 year of its occurrence. So they have 1 year of time. In this 1 year of time they can investigate and inquire each and everything related to that particular case, right? So only C is not correct. So consider the following statements regarding the office of the Prime Minister of India. Constitution specifies the procedure for the appointment and election of the Prime Minister. Is it correct? No. So likewise we have already discussed in the previous mock test, that is related to Chief Minister. Likewise here also was not mentioned the specific procedure here, right? So just if you see the article 75, Prime Minister shall be appointed by the President. That's it, right? So this is not correct. Prime Minister is the chairman of the National Development Council, right? Number of councils, commissions are there. Prime Minister is the head only. So we have Niti Aayog like that, right? So this is also correct. Prime Minister can recommend the dissolution of the Lok Sabha to the President at any time. That is also Prime Minister's choice as a head of the government here, right? So Prime Minister must be a member of either House of Parliament at the time of his appointment. Is it correct? Prime Minister must be a member of either House of Parliament at the time of his appointment. So after his appointment also he can be, he must be either House of Parliament within 6 months. Within 6 months he has to prove he is a member of either house, right? So he will be having that particular choice, right? So this is also not correct. Only two statements, 2 and 3 are correct, right? So next, with reference to the ordinance making power of the President, Article 123, consider the following statements. This is very important. Previously in the UPSC 2025 preliminary examination, this type of question was asked, right? President can issue an ordinance only when both houses of Parliament are not in session. An ordinance has the same force and effect as an act of Parliament. Is it correct? So if we carefully observe these two statements, first statement, he can issue an ordinance not only when both houses of Parliament, either house of the Parliament is not in session, he can issue these ordinance. These ordinance like sometime they will force and effect as a Parliament acts only. So for example, I will explain in detail. So we have 3 sessions, right? Totally 3 sessions we have. That is budget session, right? Budget session usually conducted from February to May, right? So and the next session, that is we have monsoon session, right? So that completely from the July to August or September, right? August end or September. Next we have winter session, right? So we have winter session from November to, we have November to December, right? So these 3 sessions are completely followed by the Parliament, right here. So both houses. So if you observe this here, July to August is the monsoon session. In October we have certain emergency, right? Urgent, important thing related to the people, public interest. So we have to create a law or make a law, but Parliament is not in session. What will do? So President will create an ordinance whenever it is important or urgent, right? So he has that power, right? So this is the October month. He can issue an ordinance. Likewise here it will have that same force and effect as an act of Parliament whenever it is not in the session, right? So but one condition here, what is that? So after the Parliament start or initiation that particular house, right? So sessions, they will completely start the approve, right? So within 6 weeks they have to approve, or within 6 weeks after completing the 6 weeks term, it particular ordinance will be ceased, right? That is the main. Ordinance time limit is just 6 weeks after Parliament complete. For example, if it is not correct or not according to the constitution rules or something, so Parliament may disapprove this. Immediately it will be ceased to be, right? So that is the main important thing here. So if you observe these two statements, means only one statement is not correct, only two is the correct statement. Next, consider the following statements regarding the special majority required for constitutional amendment. Very, very important. So procedure of constitutional amendment is very, very important related to the polity subject. It requires a majority of the total membership of the House. Is it correct? Yes. Here we have to understand that is Article 368 is related to the constitutional amendment procedure, right? So it requires a majority of the total membership of the House, that is more than, right, more than 50% of the total majority of the House, right, more than 50%. So it requires a majority of not less than 2/3 of the members of that House present and voting. This is also very important. So regarding the special majority, these two conditions are very important, right? So it is required for the amendment of provisions related to the fundamental rights. Is it correct? Yes, special majority is very much important related to the amendment or provisions related to fundamental rights as well as DPSPs, directive principles of state policies also. But if you consider this statement, it is required for the amendment of provisions related to the fundamental rights only. If it is mentioned only, then it is wrong statement, right? But here just it mentioned like it is required for the amendment of provisions related to the fundamental rights and also DPSPs, right? So this is also correct. All the three statements are correct. So next, the power of the Parliament to legislate on a matter in the state list to go effect to international agreements is provided under which article of the Constitution, right? So these type of articles are related to articles, or this type of factual information is completely not given as per the UPSC trend, but sometimes one or two questions may come, right? So power of the Parliament to legislate on a matter in the state list, that is Article 253. So whenever India is acting or agreement related to the treaties or agreements or some conventions, it is complete India's central government authority to take any action on that, right? No limit in that, right? So that particular conventions relatedly, treaties or agreements related rules and regulations are applied to entire India, entire Indian territory, not excluding any something, right? So here, for example, India ratified the climate change agreement, right? Climate change agreements like Paris agreement, right? So if it is agreed, these type of ratified, these type of conventions or treaties. So for example, here climate change means environment. Environment related issues are completely in the list of state, right? But here these type of international treaties are, we have agreements or conventions related, central government is having so much authority, right? So that is completely given in the Article 253, right? So next, which one of the following statements regarding the urban local bodies is not correct? We have already discussed Panchayat Raj institutions in the previous mock test. Now it is turned to urban local bodies. 74th Amendment Act made the provision for 3-tier system of ULBs in every state, right? So in the previous class, 73rd Amendment completely given the 3-tier system that is given by the Balwant Rai committee, right, related to Panchayat Raj institution, we have already seen. So likewise here 3-tier system of urban local bodies also were mentioned in the 74th Constitutional Amendment Act, right? So that is, we have Nagar Panchayat, we have municipal council, we have municipal corporation, these three levels, right? So but if you observe this statement, so we have already mentioned, right, I have already mentioned we have to carefully focus on each and every keyword in the statements. So it mentioned like ULB is in every state. It is not correct in the every state, right? So some states are using 2-tier system, some states are their choice, right? But they have to follow this 74th Constitutional Amendment provisions, right? So this is not correct. So the members of the ward committees are elected directly by the people. This is completely correct. State Election Commission conducts the elections to the Panchayat Raj institutions and also municipal elections. This is also correct. Governor constitutes a district planning committee in every district to consolidate the plans prepared by the panchayats and municipalities. Yes, every related things means municipalities and panchayat raj institutions, governor has the authority to constitute anything. So here especially district planning committees are constituted by the governor here. This is also correct. So only A is the not correct answer. Consider the following statements regarding the judicial review power of the Supreme Court of India, right? So judicial review, judicial activism, judicial overreach, all these are very important. So the power of judicial review is explicitly mentioned in the Article 13 of the Constitution. Is it mentioned? No. Article 13 clearly says that so any law is within or against the violation of the particular rules and regulations, whatever we have violation of the fundamental rights especially, so that is not valid, right? So that is mentioned in the Article 13, right? So here judicial review is not explicitly mentioned here, just it is mentioned implicitly, right? So implicitly means judicial, what is implicitly means? Judicial interpretation only. It is not mentioned in the explicitly mentioned in the Constitution. Say judicial interpretation or judicial inclusion, right? Implicitly means we have Article 13, we have Article 32, we have Article 131, we have Article 132, we have Article 133, 134 and 136 also we have. Apart from that we have Article 242, 143 and also 226, right? So these type of article here 32 and 226 are related to writ jurisdiction of Supreme Court and High Courts respectively, right? So all these are implicitly, judicial review is implicitly mentioned in these provisions, right? So this is not correct. So the scope of judicial review was significantly expanded after the introduction of the due process of law concept through the Maneka Gandhi case, that is 1978. We have already discussed in the previous class, right? Judicial review can be used to examine the constitutionality of both legislative and enactments and executive orders. So constitutionality means whether they are parliament or executive orders or sometimes we have legislative, right? So whether their orders are according to the provisions mentioned in the Constitution or not, right? That is the examining power, judicial review. So what is judicial review here? It is a power, it is a tool to decide or to focus or monitor or examine the actions of legislative bodies or executive orders, or we have government means administrative orders also, right? So whether they are, if they are violating any constitutional provisions, judiciary will involve and interpret them as unconstitutional, right? So the power of judicial review is an essential feature of the Constitution and forms part of the basic structure. This is also correct, right? So only one wrong, only three are the correct. With reference to the right to freedom of religion, articles 25 to 28 consider the following statements. It guarantees the freedom of conscience and the right to freely protest, practice and propagate religion to all persons, including foreigners. Is it including foreigners? Yes, Article 25 guarantees the freedom of conscience and the right to freely practice their religious, propagate religious, all persons, including our citizens as well as foreigners also. There is no partiality or discrimination here, right? Correct. So state can regulate or restrict any economic, financial, political or other secular activity associated with religious practices. So we are completely following the secularism, right? What is the secularism meaning? Division of religion from the state, right? So that is completely mentioned in this article, right? Second, both statements are correct. So the concept of equal protection of laws in Article 14 of the Indian Constitution was primarily borrowed from the Constitution of. So same question but different concepts. So equal protection of laws mentioned in Article 14. We have in the Article 14 means right to equality, right? The mother of equality article is Article 14 only. So here we have equal protection of law and before equality, equality before law, right? So these two are very important in the regarding the Article 14 here. So the concept of equal protection of laws in Article 14 completely borrowed from this United States, right? So if you observe the United States Constitution, they were mentioned this equal protection of laws in their Constitution, 14th Amendment, right? 14th Amendment. We just borrowed from the United States and included in the Article 14. Clearly we can remember these 14 simply, right? So if you observe, this equality before law is borrowed from which country? United Kingdom, right? So that is correct answer is United States related to equal protection of law. Next, which one of the following statements regarding the public interest litigation in India is not correct? Very important. It is a mechanism that allows any public spirited citizen to approach the court on behalf of the poor and oppressed, right? So here public interest, the name itself is indicating any matter related to the public interest, we or any person can litigate, means put a case, right? That is the meaning of public interest litigation. It is explicitly mentioned in the Constitution of India. Is it explicitly mentioned? No, no. So it's just a judicial intervention or judicial, we can say the judicial intervention or interpretation or creation, right? So it's a judicial creativity, right? So it was borrowed or inspired from our United States of America, right? So American Constitution, if you observe American Constitution, this public interest litigation was very important, right? So 1970s only we have taken this particular issue, right? So it is an outcome of judicial activism, right? So is it correct? Public, whenever the public interest related issues, compulsorily judiciary will intervene, right? So judicial activism, we can say whether related to fundamental rights or whether it is related to right to life, Article 21, related to environment, everything judiciary is involved, right? So it has led to the liberalization of the traditional rule of locus standi. What is locus standi here? So standing in the court, right? So a person has to be standing in court, right? So here whatever we have convention previously, so on the public interest litigation, no person can be go to the court and in front of the judge, no need to stand in the court, right? So it was completely liberalization, traditional rule of locus standi here, right? So public interest litigation, that is the important thing, liberalization we can say. So what is the not correct, incorrect here? Explicitly B is the incorrect. Next, consider the following statements regarding the financial emergency, Article 360. So we have already discussed national emergency related question in the previous test. A proclamation of financial emergency requires approval by both houses parliament within 2 months, right? So if it is national emergency, only 1 month, we have to remember this. But if it is, whether it is financial emergency or state emergency, 2 months needed, right? So this is simple difference, right? So once approved, the emergency continued indefinitely until revoked by the president. This is also correct for entire emergency provisions. The president can issue directions to the states to observe canons of financial propriety, right? So financial related, so for example, whenever the financial emergency according to the Article 360 imposed, immediately the salaries also, sometimes the president can issue direction to the state to reduce the salaries of the government officials, including the courts, high court judges and also, right? So this is the correct. The president can order the reduction of salaries and allowances of or any class of persons serving in connection with the affairs of the union, including the judges of Supreme Court and High Courts, also mentioned in that, right? So all these, to observe, all these 4 statements are correct, right? So D is the correct option. Next, with reference to the 6th schedule of the Constitution, consider the following statements. In the previous mock test, we have already discussed about 5th schedule, right? Except the Mizoram, Meghalaya and Assam, Tripura areas, right? So it deals with the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram, right? That is correct. 6th schedule is related to these 4 areas only. So it provides for the creation of autonomous district councils which have legislative, judicial and executive powers. Here completely this particular 6th schedule, what is the main aim? So to preserve or to protect the tribal customs, tribal rights and also their culture, right? That is the very much important. So we have also for Forest Rights Act, regarding the Forest Rights Act also we can observe here. So minor forest produce rights are having by the tribal people here, right? So here if you observe, these two statements are correct, right? Both 1 and 2. Next, consider the following statements regarding the no confidence motion in the parliament. It can be moved only in the Lok Sabha, right? No confidence motion is completely Lok Sabha or only in the Lok Sabha only. Why it is? The reason is, so Council of Ministers, right, are responsible. Council of Ministers are completely responsible to the, collectively responsible to the Lok Sabha only, right? So that is the main reason. It needs the support of at least 50 members to be admitted, right? So this is also very much important. If passed, no confirmation, Council of Ministers must resign. We have already discussed the censure motion, right? Censure means here just a criticism, right? In this case, a minister or a member can be resigned, may be resigned. But here in this case of no confidence motion, the Council of Ministers, entire Council of Ministers must resign. That is the main important thing. All these 3 statements are correct. So which one of the following statements regarding the cabinet committees are not correct, right? We have several committees, right? Parliamentary committees, right? In this cabinet committee are also very important. They are extra constitutional in nature. Why it is extra constitution? Why? Because they are not mentioned in the constitution, right? So they are having the powers of extra constitutional authority. That is correct. They are set up by the Prime Minister according to the exigency of the time and circumstances. Depending on the situations, immediately they will create a cabinet committees in which very senior members, most members are including as a members, right? So very, very important. So the membership of the cabinet committees is restricted only to cabinet ministers? No. Other ministers, other individual ministers also can be including as a cabinet committee members, right? So this only statement is not correct, right? So they are an organizational device to reduce the enormous workload of the cabinet. So here, what is the main aim of creating these cabinet committees here? So just to scrutinize or examine some important legislations or policies before going to the cabinet, right? What will they do? They will just scrutinize these important things related to security or some economic or administrative related things, right? So appointment related things, etc., right? So then they will go to the cabinet committees after examining by these cabinet committees, right? So only this C is not correct. Next, consider the following statements regarding the writ of certiorari. It is issued by a higher court to a lower court or tribunal to quash an order already passed by either. So we have already discussed the writ of prohibition. Prohibition means it is a just prevention before enacting any law, right? So this is or giving a judgment, right? So it just protect or it just control or it just stop them. But already if they already created or already given an order, then it will use or issue writ of certiorari. That is to cure, right? So to quash an order, completely dismiss the particular order given by lower courts or tribunals here, right? So it is a curative writ. That's why it is a curative, means curing, right? Preventive is completely writ of prohibition, but here curative is writ of certiorari, not a preventive one. This is also correct. It can be issued against administrative authorities performing judicial or quasi-judicial functions, right? So whoever are following or operating here, administrative authorities already discussed, right? So the Central Information Commissions, Central Administrative Tribunals like Central Information Commission, we have State Information Commission. These are tribunals which are functions with a quasi-judicial functionaries, right? So these can be issued against them, right? So and it can be issued against a private individual or body? No, these are not against any private individual or body, only against lower courts or tribunals or administrative authorities who are performing judicial functionaries or quasi-judicial functionaries, right? So only two statements are correct. Next, with reference to the doctrine of severability, consider the following statements. This is very important question, doctrines, right? So this is a principle or doctrine of, we can say, separability. Separability means, what is separability here? So for example, central government or any state government, right? So they created a law, right? This is a created a law, right? So in this, a portion of that particular provisions of the law is not or not according to the provisions or against the constitution, right? So then it will be invalid. It will be invalidated by the courts. That is called doctrine of severability, right? So here these provisions completely are not valid according to the doctrine of severability, right? It is enshrined in Article 13 of the Constitution. Why? If you take the Article 13, what it clearly says that if any provision or any particular statement according to the law, right? So those are completely against or derogation of the fundamental rights, right? So completely they will be void or invalidate, right? So that is the main. If it states that if a part of law is unconstitutional, the entire law must be struck down. Is it correct? No, no need to struck down entire law. So if it is a part of law is unconstitutional, only that part of law is separable. Separability, right? That is the principle here. So this is not correct. But if you take this particular example, we have Minerva Mills case, right? You take the Minerva Mills case. In this particular case, Supreme Court given or excluded or unconstitutional, provided the excluded some important provisions mentioned in the 42nd Constitutional Amendment Act, right? So that is very important. 42nd Constitutional Amendment Act 1976, whatever some of the provisions mentioned are unconstitutional, that were completely excluded or unconstitutional, invalidated by the court in the Minerva Mills case. So these are certain examples. We have certain A.K. Gopalan case, right? So these are certain examples. So here only A is the correct option. Consider the following statements regarding the National Commission for Women. So we have already discussed national commissions and also these statutory bodies also, right? So it is a constitutional body established under Article 338B. Is it correct? So we have already discussed 338 and 338A, 338B. These are related to scheduled areas, right? Or scheduled castes, right? So National Commission for Scheduled Castes. 338A is related to National Commission for Scheduled Tribes. 338B is related to National Commission for Backward Classes, right? So these were included by the 89th Constitutional Amendment Act 2003. So but not, this is correct regarding the National Commission for Women. So National Commission for Women is a statutory body, not constitutional body, right? So that was created or enacted by this National Commission Women for Women Act 1990. This is very important, right? So not correct. It is mandated to review the constitutional and legal safeguards for women. It is also correct. It is mandated to do this particular provision or rules. It submits its report to the central government, which lays it before the parliament, right? So this is also correct. 2 and 3, only 2 are the correct. So the constitutional provision that deals with the protection and improvement of environment and safeguarding of forest and wildlife as directive principles of state policy is. So this is also a straight question, but very, very important question. So here, if you observe the directive principles of state policy that were mentioned under Article 36 to 51, right? We have, right? So 51. So especially if you take the article 48A, we have mentioned this, right? Protection and improvement of the environment and safeguard of forests and wildlife as a directive principles of state policy. Here we have fundamental rights, we have directive principles of state policies, we have fundamental duties. These three are very important in the constitution. Fundamental rights are enforceable. Directive principles of state policies are not enforceable. So fundamental duties are also not enforceable, right? So here just these are rules. There will be no punishment, right, regarding these rules, right? So if you observe same thing, we can observe in the article 51A subclass G. What is it? It is a fundamental duty, right? It is a fundamental duty of a citizen to protect environment, forests and wildlife in India, right? So this is corresponding provision in the mentioned in the fundamental duties also, not only DPSPs. So we have to correlate these type of issues whenever we are reading the Indian polity, right? So this is information. Next, which one of the following statements regarding the estimates committee of parliament is not correct? So it is the largest parliamentary committee. Is it correct? We have already discussed previously public account committee, that is including only from the opposition parties, right? So it will include 22 members from Lok Sabha, 7 members from Rajya Sabha, right? So it consists of 30 members, all from Lok Sabha only, not including Rajya Sabha, right? So this is also correct. So as such as more than 22, we have 30 members almost. That's why it is a largest parliamentary committee, right? So this estimates committee especially complete the role, a standing committee that examines the estimates including the budget and suggests economies in public expenditure, right? So it will help to control the particular estimates or some sort of debts, right? So next, chairman of the committee is invariably appointed from the ruling party. Is it correct? Is it correct? Completely it is related to the Lok Sabha only. Then chairman of the committee is appointed by the speaker, right? Speaker only here. By the speaker only, the chairman of the committee is invariably appointed from the ruling party only. This is also correct. All 4 options are correct completely. So we have to mention this as opposition party, but so unlike PSC, it is ruling party only. So this question, it will give 1 mark add if you attempt it, right? So this question has all are correct, right? So next, with reference to the fundamental duties, article 51A, consider the following statements. They were added to the constitution by the 42nd Amendment Act 1976 on the recommendations of Swaran Singh Committee. Yes, they were completely added by the Swaran Singh Committee recommendations by including the 42nd Amendment, Constitution Amendment 1976. They are non-justiciable in nature. Yes, DPSPs are non-justiciable. We cannot go to the court whenever state is imposing any law on the particular provisions or related to the violation of the particular related provisions, whatever mentioned in the DPSPs, right? So and also they are applicable only to the citizens of India. Is it correct? Yes, only to the citizens of India only, right? The duty to pay taxes is one of the fundamental duties. Is it correct? Is it correct? So non-justiciable in nature, we have DPSPs, we have fundamental duties. All these two categories are non-justiciable, right? And if you take fundamental rights only, they are justiciable. Whenever there is any violation by the state, violation of the fundamental rights against by the state, we can go to the court directly to the Supreme Court, right? So they are applicable to only citizens of India. The duty to pay taxes is one of the fundamental right. Is it correct? No, right? So we have certain 11 duties almost. We did not mention any these type of duties, right? So only 1 is not correct, 4th is not correct, 1, 2, 3 means only 3 are the correct. So these are the 25 questions. Holistically, we have explained everything, each and everything, and also we have just connected to relevant topics, right? Whenever we talk about president, right? President ordinances we have, right? So if you talk about president ordinance, we have to correlate with the governor ordinance powers also. So president's article power is article 123. If you take governor article power, article 213, right? So these are correlated items we have. So again, PM and CM related, whether their appointment is mentioned in the constitution or not, these type of correlated things we have to observe in the Indian polity especially. So these are the 25 questions from the test, mock test 3. So this is the key. 24th, except 24th key, everything is okay. 24th is all are correct, so you will get 1 extra mark if you are attempted, right? So thank you very much, all the very best.